Nothing on the show is to be construed as legal advice. The contents of this show are for informational purposes only.
Hello, welcome to Know Your Rights, the Consumer Lawcast, with me, your host, Abbas Kazerounian. We've got an amazing show for you today that is very relevant considering what is happening in the world right now with the COVID and the economy. Bankruptcies certainly seem to be on the rise, and we've got a really special guest. We've got Ahren Tiller, who is a certified specialist by the California State Bar as a bankruptcy specialist. Welcome, Ahren.
Thank you. Thanks for having me on the show.
So as a starting point for those of our viewers and listeners that don't know the difference between a normal bankruptcy attorney and a certified specialist, is that it really, like, the State Bar of California has stated, because of certain exam. Do you have to take an exam, Ahren?
Yes. So in order to become a certified specialist, first off, you have to have been practicing bankruptcy law for a considerable period of time. You also have to have done quite a few different types of bankruptcy, Chapter 11, Chapter 7, Chapter 13. And then there is a test, too, that is administered by the Board of Specializations of the State Bar of California. And if you pass that test and you get other peers in the field, can certify that you really understand bankruptcy law, then you're certified as a specialist. So
I can tell you all that. I've been working with Ahren for a fair few years now, and when it comes to bankruptcy, the guy knows his stuff, because I'm kind of like a deer in headlight when it comes to bankruptcy. And so, I think the fact that we're going to be talking about bankruptcy, we're talking to the right person here. And I've already told Ahren, because he is a specialist, he talks at a very high level. And I've told him on this show, we don't talk any legalese because we want to tailor this for you, the consumers. So first of all, how are you doing, man, in this COVID period?
It's been an interesting time. We had to shut down our office. As you can see, I'm working from home. We're attending court. The bankruptcy courts have adapted. What we've done is all hearings. So normally when you do a Chapter 7 or a Chapter 13 or even an 11, you have a meeting of what's called a meeting of creditors, and you sit with the trustee and talk about your case. We normally do that in a packed room with 15 other people, but due to social distancing now, it's being done by phone. And so, but how am I doing? We're all getting by. It's been strange times, but we're all trying to make the best of it.
For sure. It's just been absolutely nuts. Kind of dealing with how our culture has changed with being what's going on. We're stuck at home. We can't travel and all this kind of stuff. But on a work front, a lot of people have been losing their jobs. Unemployment is at unprecedented numbers, and people are concerned. And just as an overarching question, because I think you're, if not the highest, one of the highest, but I'm pretty sure you're the highest filer in San Diego County in California. And I know you practice all over the state, but specifically San Diego County, you're one of the highest filers. Has the number of bankruptcy filings increased over the last 3 months?
It actually hasn't. The filings, and I have many hypothetical scenarios, why this is. But I really think being on the front line, we've been open throughout this whole pandemic. We've been open through the shutdown of COVID. We've been operating, we weren't doing in-person meetings with clients, but we were doing them by Skype or over the phone. And I think the number one reason I would say that there's been a decrease and not an increase, as people would imagine, is March and April, it's almost, I say, like Maslow's hierarchy of needs. People were worried about protecting their family, feeding their family, and toilet paper. Whether they're going to have the ability to feed their family. That's just priority number one. And I think people getting your finances in order, dealing with your creditors, I think it takes second. Obviously, it's second to you feeding your family. So I think people were focused on keeping themselves safe, feeding their family. And now, as June approaches, as we've gone through about 90 days of quarantine, and people are starting to either go out, and the world seems to start picking back up again. And the creditors, that was the big thing. Most creditors were delaying collections. A lot of civil courts were closed. At San Diego County Civil Court, you couldn't sue someone. If you filed a lawsuit, it just sat in a pile waiting to be opened. And I think the best analogy I can give you is like a tsunami where the beach dries up and the deluge of water goes out, and there's a wave of filings coming. And I think
So
there was.
it's kind of like a domino effect, I guess, because our last 3 months, people were getting in debt, losing their jobs, and the consequences of that are going to be coming in the following months, you think?
I believe so. And I think that the people I talked to who were retaining, if there was an emergency, if there was a repossession, if there was a lawsuit, they were filing. But a lot of people were hesitant to pay for a bankruptcy lawyer to take that action. They were focused more on making sure they had toilet paper and food and shelter. And I do see as we're entering June, and because what another thing that occurred during this time is there was a lot of Band-Aids. They were temporary solutions. The CARES Act, the extra $600 people were obtaining in federal aid for unemployment. They, instead of making the regular $450 on average a week unemployment, they were getting $1,000, and that is a Band-Aid. It's going to expire at the end of next month. And these are things that
in California, I think landlords couldn't collect on delinquent rent under certain conditions. If the tenant had given specific notice to the landlord that they've been affected by COVID, they can't make rent. There was some kind of moratorium that the governor had put on.
And that was to the stay-at-home order. I think it expires June 15th, possibly at the end of this month. I have to look into it. But even San Diego County, for instance, the board of supervisors passed a moratorium on evictions, and they stated that if you can show that you fell behind on rent and it was anything COVID related, that landlord could not evict you. But the problem is that's just a Band-Aid. That doesn't mean that nothing in the statute says they have to forgive the loan, the rent that was past due. And with FHA lenders, the Federal Housing Administration, most loans, they had the same type of moratorium. And a lot of these lenders were giving people what's called forbearances. You don't have to pay your mortgage for 90 days. But if you read the fine print, a lot of these forbearances just state that you have 4 payments due in 4 months. So it was this temporary solution, but the underlying problem of loss of job, loss of income, and falling behind on your bills, it's really just kicking the can down the road till July and August. And that's where I see a real issue we don't have a long-term solution. We had a lot of temporary solutions hoping for the best case scenario that we're just going to all return to work and everything's going to go back to normal. And if it doesn't occur, there's land.
I'm sorry.
Yeah.
I said, from what you're saying, it's almost like the problem is going to be compounded because it's going to be piled on. Like suddenly now I owe 4 payments and I just lost my job. It's like it's going to be worse almost.
And then you're also got used to, or at least, it's hard enough during tough times to budget. It's hard enough during regular times to budget, but to do so during difficult times, it's almost impossible. People were getting $1,000 a week are going to go back to getting $450 a week on unemployment. And just imagine how that will affect people's overall ability to pay their mortgages, pay their rent, pay food. I mean, we're heading into some troubling times, and I think, bankruptcy, although it can't solve, a lack of income and ability to pay for basic needs, at minimum, it can give people relief from creditors, which they're on the sidelines waiting, and they may have given a 90-day forbearance, or they may have given a 90 days till they're going to sue, but they're coming, and they're getting ready for the courts to reopen and the lawsuits to get levy and garnish. And there was even a lot of talk when the CARES Act passed, which was the stimulus, that they wanted it to be able to be levied by creditors, that they wanted to get a piece of it, that they tried, so that it wasn't fully exempt. So there is no exemption protection from levying even CARES Act money. So
what you're saying, there's a lot of things to think about there from the listeners and the viewers' perspective. But let's move forward. Let's say we're beginning of July now. It's all catching up with me. I'm just average Joe living on Main Street. I've fallen behind on my mortgage. I've lost my job. And the creditors are now starting to call, and I'm scared. I don't know what to do. And I'm thinking, well, maybe bankruptcy is the right option for me, or at least it's something that, an avenue I want to pursue. So kind of like a 2-tiered question. Let's go with the question with the first tier is like, because bankruptcy is not an automatic option, right? Because you have to qualify for bankruptcy, and I don't think many people understand that. And so, and for most consumers, there's two different options they qualify for, either a Chapter 7 and a Chapter 13, and I'll have you explain that in your answer, which is what makes somebody would make somebody potentially qualify for a bankruptcy, and how do you know if it's a 7 or a 13, and what distinguishes the two?
All right, so the most common bankruptcy that people do is a Chapter 7. And in the most simplest terms, a Chapter 7 is a liquidation. It's like in the movies where you see, the mansion, everyone's loading the furniture onto the truck, and they had to sell everything. And the reason why that's because in essence, it's a liquidation. They're going to sell everything. And in the most basic, simplest terms, it is a 90-day process typically, whereby a person says, I'm done. I cannot afford my creditors. I want the lawsuits to stop. I want the levies to stop. I want everything that's occurring to stop, the calls to stop. And so you file. There's an automatic stay, which is basically an injunction. It's a timeout. No more phone calls, no more lawsuits, no more collections. And then if you have assets that are not protected, and we use the word exemptions, then they're sold off to pay creditors. And at the end of that process, say you had $50,000 in the bank, but you owed $1 million. Well, if you were we could exempt in California $28,934 under the wild card exemption, California Civil Procedure 703. So you could protect that. The remaining $22,000 or $21,000 and change, you could turn over to the trustee. The trustee takes that $21,000, spreads it evenly amongst your $1 million of creditors, but at the end, you're debt-free. You're done. And a lot of those Chapter 7s, though, because California has some decent exemptions, you can protect $28,000 in change in cash. You can protect an additional $5,000 in a car. So a lot of people, I'd say almost every one of my clients, especially with a little bit of planning beforehand, can file bankruptcy, wipe out their debt, and actually not lose any assets, not lose any property because we fully protected them. We exempted those under those exemptions. So that's a Chapter 7. It's a 90-day process. You file approximately 30 days after filing. You go to a hearing with a trustee who's appointed to sell assets if they can, or determine if there's assets. If there's no assets, they do a no distribution report. They say everything that this person owns is protected. And then 60 days after that hearing, if no one objects to the discharge and nobody comes screaming saying, oh, he's lying, he's got a house in Mexico he didn't disclose, ultimately they get their discharge. And that is a final order that wipes out all of your debt. And it even shows up on your credit report as a zero balance owed, discharge in Chapter 7.
Okay, so let's stop right there. Some takeaways here. If you qualify for a Chapter 7, at the end of the process, all your debt is wiped clean. Fair?
Fair.
Okay. So
with some exceptions.
With some exceptions, but the general rule of applicability, like for the most part, your credit card debts, your medical bills, we're not talking about student debt, because I know you can't bankrupt away your student debts, correct?
In 99.99999% of the time, student loans are not going to be discharged. It's a very extremely difficult test that you have to pass to get them discharged, called the Brummer test. And it's a very high standard. I mean, the few cases I've seen and done, people who are in vegetative states, you truly have to prove you'll never be able to pay back your student loans. And then with federal, it's even a higher standard, because there's options of IBR, which could take the payment to zero. And so, yes, it's most rule of thumb, student loans will survive a bankruptcy.
Okay, so that's number one. Number two is that when you start the process, even your creditors cannot call you anymore, because they get notice that you have filed a bankruptcy, right?
Yes, that's the automatic stay.
And you describe that as a timeout.
Exactly. I mean, it's called a stay for a reason. Stay, stop. Everything stops.
Okay.
It stops. If you have a foreclosure tomorrow, it would stop it. If you had a repossession tomorrow, it would stop it. If you had a lawsuit, it would make this lawsuit be paused, and you'd file a note. The plaintiff, the person's creditor suing you, would literally have to go down to the courthouse. It's their duty, and notify the court that there's bankruptcy, and everything stops.
Perfect. Now, quite often, this stay, as you call it, is violated by creditors. Like, they get the notice, but they continue to call the consumers. Now, if I'm your client, and I've filed this timeout, this stay, because my bankruptcy has commenced, and my creditors have been notified that I filed bankruptcy, but this credit card company just won't let up. They keep calling me. What do I do?
So, most important thing is call your lawyer. Tell your lawyer about it. I mean, I can't tell you how many times, there's a creditor just violating the stay, and even then the subsequent discharge, just violating, and it defeats the whole purpose of them filing bankruptcy. I mean, so the whole purpose of filing bankruptcy is to give you the timeout, stop the creditors, but that stay lasts until you get that discharge, and that discharge is the order that forever those debts are erased. You owe zero. So it's an injunction to say these debts cannot be collected upon. But if someone violates an injunction, you have two options. The automatic stay is under 362K. If they continue to violate the law, you can file what's called a motion for contempt and a sanctions motion, or you can file an adversary proceeding, which is basically a lawsuit in bankruptcy court. And not only can you get back any money they took or any damages, and sometimes there's compensatory damage to compensate that debtor and we refer to, in bankruptcy, we refer to the person who filed as the debtor. It's like plaintiff and defendant, it's the party. That person who the creditor violates, not only do they have to pay damages, but your lawyer, it's set up in the statute that obviously if you're filing bankruptcy, times are tight. Financially, you can't afford to pay a lawyer to sue somebody. Mm-hmm. So they have what's called statutory attorney fees. So in the statute, if a creditor like Bank of America were to violate the stay, they will end up having to pay your attorney's bill to enforce the stay because they should have done it voluntarily. So the first thing, tell your lawyer. What I typically do is I'll send a warning letter, because there's case law out there that talks about the stay and the discharge is a shield, not a sword. That you're not supposed to be suing them to make money, but without that shield, without the ability to sanction them and have them pay damages and pay your attorney fees, there is no shield. There is no protection. There has to be a stick to enforce that stay.
Right. Now, outside the Ninth Circuit, and for our viewers that don't know what the Ninth Circuit is like the Western kind of states, like Washington, Oregon, Nevada, Arizona, California, Alaska, and Hawaii, and Idaho as well.
Idaho.
Yeah. That's the Ninth Circuit. But outside of the Ninth Circuit, if there is a stay violation, if they're violating the timeout, you actually would have potentially an FDCPA case, which could be a sword, right?
Yes. And actually, it's interesting. I'm arguing this issue on Friday before the Ninth Circuit regarding, that's a case called Walls versus Wells Fargo. And that case basically said that a FDCPA based upon a discharge violation cannot form the basis of an FDCPA claim. And not to get too into legalese, but they basically stated that Congress didn't provide a private right of action under what's called 105, the discharge. Therefore, by doing an FDCPA, you're getting through the back door what Congress didn't provide through the front. That's the rationale, is that by not providing a right to a jury trial, not providing a right to file a lawsuit under 105, which is the discharge injunction, that a violation of the FDCPA based solely upon a discharge violation wouldn't be actionable under the FDCPA. But you're right, outside of this district, they've all ruled the other way. And so there's a circuit split on that. And typically that'll take the Supreme Court or the Ninth Circuit to go en banc to, which is they basically review rulings. So it's an interesting issue, but you are correct. FDCPA violations could be based in all other parts of the country outside of the Western states on purely a discharge violation.
Interesting. Okay. And then the third takeaway from the bankruptcy, Chapter 7 filing is that you said you called it a liquidation, but I don't want the consumers and our viewers to be necessarily too concerned, because there's not going to be much of a liquidation unless you have a lot of assets, right? And with the right lawyer, someone like yourself that is very well educated in the bankruptcy arena, you can do a lot of asset protection so that you can keep a lot of your assets and still file bankruptcy and not be concerned that you're going to lose, a bunch of stuff that you own, right?
Exactly. And that's why I mean 99.9, I'd say 1 to 2 out of 1,000 cases that I've done, we actually sold, like let the trustee sell stuff. And it was almost all, and every time, unless, there's a couple times people just don't tell you about things and it's unfortunate, but 90, even there are times when it makes sense to give up an asset. But if you have enough time and planning, if you consult your attorney before you have a foreclosure the next day, before you have a levy coming that they're garnishing your paycheck, before these things, with enough time and planning, we can protect everything. I mean, there's ways to do it. And sometimes it doesn't make sense to, if you're paying 5 cents on the dollar, that's a great deal if they have too many assets. But we have a homestead in California. And so you could protect, if you're married, $100,000 in your property, $75,000 if you're single of equity, and that's after cost of sale, and $175,000 if you're over the age of 65. So that a lot of people are hesitant to even consult with an attorney because they just assume, I don't want to lose my house, I don't want to lose my car, I don't want to lose all my stuff, because they think, oh, it's a liquidation, I'm going to just have to sell everything. It's not the case. 99.9% of my cases, the people do not sell anything. The case just resolves with a no distribution of assets, because we have pretty extensive exemptions, i.e. protections in California to protect assets. And even if we have assets that are over those levels, we can do things. It's called asset planning and exemption planning. And there are ways to do so with time to protect your assets.
And I think it's important to kind of like, drop a footnote, and I've kind of alluded to it already. And that is where I think, from a consumer's perspective, who you choose to be your bankruptcy lawyer is an important decision. I mean, I don't do bankruptcy personally, but Ahren does. And so and the thing is, the reason why I chose Ahren to be on the show is one of the few bankruptcy attorneys that I trust, because he actually really is a student of the law, and on an academic and a legal level, really knows the bankruptcy code. And so it's very, very important to choose your lawyer carefully so that they can help you with that asset protection and really bring you through the process, that 3-month process that he was talking about, in an efficient manner, while protecting your rights and making sure that all your exemptions are being utilized, and so that you come out of it looking as rosy as you possibly can, going through what is, a fairly traumatic experience, because nobody likes to file bankruptcy, but it's sometimes a necessity of life. And
I would just, the best analogy I give to people is filing bankruptcies like walking across a minefield. But without a good attorney, you have no idea where those mines are. I do. And I can't tell you how many unfortunate people don't come to our office and first go to an experienced bankruptcy counsel. And that's, the damage is already done. Now I'm in damage control. I have to fix a problem that prior to filing, we could have resolved very easily. Because once you file, there's no reset button. You can't just dismiss the Chapter 7. So it's very important that you sort out all these issues on the front end before you file, because after you file, you can't undo it. And a perfect example, it was an unfortunate instance where a woman, she had not come to my office first. And about a week or two before filing bankruptcy, she borrowed $10,000 from her mother and paid her property taxes that were past due. And 4 days later, she got her big, large tax refund and repaid her mother. Now, it seems innocuous, totally normal, just a quick bridge loan, 4 days. But the problem is, any repayment of a debt, especially to an insider, a family member, within a year of filing to an insider or 90 days to another creditor, is what's called a preferential payment. And so she filed, and the trustee sued her mother for the $10,000 to claw back and distribute that payment equally to creditors.
Wow.
Had she come to my office, I could have explained, no, don't do that, or given her the advice to not have done that bridge loan. Or sometimes people give they'll think they can't protect their car. They'll transfer it to their brother for $1. And all we would have to do to fix it if they'd come into my office before filing is just transfer it back and protect it, because it could have been protected.
So there's a really good takeaway here, which is if you're even thinking about doing bankruptcy, and there is some kind of like, you owe your brother money, your best friend money, or whatever, don't do anything. Just go consult a lawyer first, and then a good lawyer, should I say, that knows their area. And at that point, you can make an informed decision of whether what you're doing or not is going to be harmful to you. So that's interesting. So let me change.
I can't stress that enough. I mean, that is, don't do anything without talking to your lawyer. And I think that applies in a lot of areas, but in bankruptcy, I just cannot tell you the amount of times that I go, why didn't you talk to me before you did this? Transferring $10,000 to their son, doing just certain things that I think people had the best intentions. They thought they were doing the right thing, and they made my life and the job so much more difficult because we have to undo the damage. It's so much easier to plan it out and do it correctly from day one, as opposed to clean up the mess later.
Yeah. And then, so let's change gears a little bit. So the people that what are the fundamentals of whether somebody qualifies for a 7 or not?
So so the first test, obviously, we talk about is we want to make sure we can protect all your assets. So when I do initial consultation, we do a free consultation. We sit with our clients, and I go through their assets and just with the value of their house, how much do they owe on the house, how much equity, and if they want to keep their house, which almost everyone does, and there's too much equity, then that might be a deal breaker. And then we have other options, not just a Chapter 7, but that's the first thing. So number 2, if we can protect all their assets, then in 2005, in October of 2005, they passed the Bankruptcy Abuse Protection Consumer Relief Act, which is BAP-CPA is what we call it, in the acronym. And that instituted what's called the means test. And it basically, if someone has a consumer debt, mostly consumer debts, 50% or more, it's not based upon a failed business, it's not tax debt, it's mostly credit cards and things used for household purposes, is the definition of consumer debt. Then they have to pass what's called the means test. And the means test is, on the simplest form, is, are you below the median income? Does 50% of the population of the area you're living in make less than you or more? And if you're on the lower side, if you're below the median, you qualify. I mean, outside of
that's geographically specific, right?
Yes. So the means testing is
somebody living in San Francisco is going to be like, they get to earn more and still qualify for the means test than someone that lives, I don't know, in Bakersfield, for example.
Right. And they update these. They're constantly updated, and it's important to know the median income. But even if you're over the median income, there's a long formula that I won't bore your viewers and go into, but it basically looks at your income, your gross income, deducts taxes, healthcare expenses, and it's a long, drawn-out formula based upon IRS standards. So it's not based upon what you actually spend. It's based upon what a family of 2 is supposed to be spending on food, clothing. So basically the bare essentials of life. You got to pay taxes. You got to pay your health insurance. You have to pay housing. And these allowances by the IRS standards, if after deducting those and deducting your actual mortgage payment, if you have one, or your actual car payments, if you're negative, meaning you don't have what's called disposable monthly income, you have no money or not enough to do a viable Chapter 13 repayment plan that we can talk about in a minute, then you should qualify for a 7. But in the simplest terms, the means test, the income means test, is to determine whether you could fund a plan, a Chapter 13 repayment plan, based upon your excess income after paying the essentials of life. Could you afford to pay that and pay a substantial amount, approximately over $10,800 over the life of a 5-year plan? If that's the case, they would want to put you into a 13 repayment plan, and you wouldn't qualify for the 90-day liquidation.
And on a 13, the big difference is that you have to pay what the trustee has agreed that you have to pay as part of the debt, and whatever that reduced amount is, or do you pay 100 cents on the dollar? It's usually like
so. You could do 0 cents on the dollar or 100 cents on the dollar, and it's part of, so a Chapter 13 in the most basic levels is a repayment plan. It is a structured, cookie cutter, quick and easy reorganization repayment plan. So on the simplest level, if somebody owed $60,000 in debt and they can't afford their minimum 28% credit card payments that are $2-3 grand a month, but 60,000 divided by 5 years, 60 months is $1,000 a month, and they could do, that's 15, for if your minimum credit card payments on 60 grand are $2,500 a month, well, you're saving $1,500 a month by doing a mere $1,000 payment. And how that works is we would file your petition just like you would in the 7, but we would then do a plan. And that plan is determined by 3 things. Liquidation, meaning it's not fair if you get more money. If your creditors got more by selling your assets in a 7, then you repaid them in a 13, that's not going to fly. That won't be approved. So the bare minimum is the creditors need to get what they would have gotten had you sold your assets in a 7. But the good part of 13, which many people do not like the repayment plan aspect of it and the length of the plan, but the best part of a Chapter 13 is you do not lose any assets. That's you maintain possession of all your assets. You're not going to lose your home. You're not going to lose your car. You're not going to lose anything. So you control the assets of the state, and so all of your assets you keep. Now, the payment plan is based upon your income, how much you can afford, based upon a budget that we draft and we show. The liquidation, it's got to be at least the amount that they would have gotten in a Chapter 7 if they sold your stuff. It's got to be the amount of money you have left over after paying rent or mortgage, food, clothing, school supplies. And then the third part of the Chapter 13 is you have to, at minimum, pay back all the priority new tax debt. Like, so if you had a secured creditors you wanted to keep or cure, a lot of people I put into Chapter 13s don't pay any money to their credit cards. Sometimes they'll just take their car, take the $30,000 car loan, spread it over 5 years, lower the interest rate, and just pay their car and maybe any past due amount they owe on their house or tax bills, and they can just pay taxes. So I've had clients that had a $500 car payment on a $15,000 car loan, and they were paying $300 to the IRS, so they were paying $800 a month. I've taken their $10K of taxes, their $15K car loan, and put it at $500, saving them money. I put them in a $450 a month plan payment and I'm wiping out all their credit card debt, whereas they were paying $800 or $1,000 to their taxes and cars before filing. So they actually save money, and at the end of the process, they get that discharge just like in a 7 that wipes out all their debt.
So if you don't qualify for the means test to go into a 7, but your disposable income after your necessities doesn't add up to the minimum payment of your consolidated debts over 60 months, does the trustee then reduce it from 100 cents on the dollar to something that is affordable within that disposable income?
Yes, so that would be a Chapter 13 plan, and we call the pot that we call it general unsecured creditors. Basically, credit cards, payday loans, past due amounts. Those debts that are unsecured, they're not. It's not like a car loan or a mortgage. They're not secured to anything. You can pay 0% to them or 100% to them or anywhere in between. And so if someone had $200,000 of credit card debt and we were doing $1,000 a month plan payment to creditors, $60,000, that would be a 30% plan. They got 30 cents on the dollar. And at the end of that process, the remaining 70 cents that weren't paid and any interest that had accrued, that gets wiped out.
Got it. Understood.
In the district.
So let's move on a little bit. So somebody's heard your talk and they're thinking, yeah, this is a viable option for me, and I definitely want to go see Ahren and talk about it. What information, what is it like you're in an ideal world? And I know this is kind of like a hypothetical I'm giving you, but if you had the perfect client, when they come into your office for their consult, what would they be bringing with you in a minute or less?
Most important thing, what is your income? You'd be surprised that people do, they don't study their paycheck as much as they know how much gets deposited in their account, but I need to know how much they're paying in taxes, what are their deductions, what their gross income. So an important thing is a pay stub. Very important they bring in a pay stub. How much debt they own, having a credit report is usually not that important. The most important thing is to have a good idea of what you own, assets. If you have some unliquidated assets, such as maybe a possible lawsuit or things of that nature, I need to know about them. So I would say the most, but number one, the most important thing to bring to a consultation is a pay stub, because with that pay stub, we can run that means test in that free consultation very quickly and easily and knock that out. And I can't tell you how many clients will tell me they don't bring a pay stub. They tell me this is their income, and later on, I have to realize, oh no, that was your net income. Your gross income is $3,000 more, and you're contributing so much to your 401k. And so your take-home pay may look like you qualify, but your actual pay, if you stopped contributing to your 401k, you don't qualify for a 7. And so it's important. The pay stub, I think, is the most important, and also really knowing what you own, especially if you have.
To what degree? I mean, like, they have to come with like an itemized list where, for example, they show you they own like 15 wine glasses, they own like, like the furniture. Like, I mean, how specific are you talking?
No. So the part about furniture in California especially is just, it's all protected. I mean, unless you have a Picasso on your wall or the best TV that Best Buy can sell, and this year, not 5 years ago, everything in your house can be protected up to $750 per item. So when I say per item, the chair, each, as long as you don't have antique furniture.
Okay, well, so what about somebody's engagement ring that may have cost $20,000 20 years ago when they were given that as a gift for their engagement? I mean, if it's a $20,000 ring, did they have to declare that?
They have to declare it, but as I stated, there's the best exemption California has is CCP, California Code of Civil Procedure 703, and that is the wild card exemption, commonly referred to as the wild card. And it's called the wild card because it protects anything. So I can take 28,000. It changes every year, but 28,924, I believe it is right now. That amount might be, I've just got the 29. So there's almost $30,000 that you can just put on diamond rings, cash, cars, whatever it is. Then there's also an additional $1,700 exemption for just jewelry. So if you had a $30,000 ring and you didn't have much else, I could protect it. And so if you paid 20 for the ring, very likely the trustee, if they were to sell it, would only get 12 to 14 at an auction, because there's a reduction, obviously, if you're selling stuff in bankruptcy. So if the ring was bought for 20, I think we could easily protect it as long as you didn't have another 15K in the bank. And if you did have 20K in the bank, well, we can talk about, well, what could you use that money to spend on? And that's what I talk about with enough time and planning. For instance, you could, if you hadn't contributed to a retirement account that year, you could take 6,000 of that 20,000 and put it into an IRA. And that IRA is protected because it's it's protected under the federal exemptions as an ERISA qualified account. So there, any retirement account that's tax exempt. So I could take 5 of that 20, put it in your retirement account, slap the wild card on the 15K cash, slap the wild card and the jewelry on the ring, and you're fully protected. So there's a lot of ways to protect as long as I have time.
So the takeaways, if you're going to see someone like Ahren, number one and the most important thing is your pay stub. Number two, have a good idea of what you owe to who you do owe it to. And there was something that Ahren mentioned that may be a little bit confusing. He said, for example, like unliquidated assets, and he mentioned the lawsuit. I don't want you guys to get confused. What he's talking about is not if you're being sued, let's say, by a credit card company, but the other way around. If you have an asset and you're the one that's most likely to make a claim in a lawsuit, if you've got a claim against somebody else, that is something that should be disclosed, and you should let your lawyer know about that, because potentially that could be exempted out if the value of it is less than $10,000, for example.
And that's so important because I think people think of assets as my car, my house, my furniture. They don't realize that unliquidated, and when I say unliquidated, it just hasn't been turned into cash yet, a claim. If you have a personal injury suit where you were rear-ended and you were severely hurt, that's an asset. That is something that you have to disclose.
I actually have a kind of a story about this. So, like, the viewers know that, we do a lot of class action work, and my client had, unbeknownst to me, gone and filed bankruptcy. And this was a multi-million-dollar lawsuit. And the bank knew that I was suing, that they would have probably had to put 8 figures on that settlement. But what they did was they found out about the bankruptcy before I did, and they went to the trustee and bought the claim for $30,000.
And the unfortunate thing is the trustee steps into your shoes. They take your case. And the worst part is, and this is why it's so bad, is the trustee only has a duty to the creditors. The trustee's sole job is to sell your stuff to pay creditors 100 cents on the dollar. That's it. And so, although that could have been $1 million suit, the trustee cared. What the trustee cared the most about was paying the creditors. And so I bet you there was $30,000 in creditors. They accepted the $30,000 from the bank and paid off the creditors, and they had no duty, fiduciary or otherwise, just to the actual person who filed. And so they can hijack a lawsuit. And so, as I was saying, with enough time and planning, we could either wait before the case to see if the case settles, or we could structure it in a way, because in California, if it's a personal injury case, there's exemptions under 704, that California Civil Procedure 704, that do not protect maybe cash in the account, so which we can spend down or move to retirement accounts. But there's a high exemption if it's, as long as it's reasonable and necessary for to protect the entire personal injury award. Yeah. There's another $50,000 exemption, but there's an exemption that's even higher under 704. So we call it exemption planning, but it's asset planning, exemption planning with enough time, and you do it before filing, preparing for it. You can avoid these mines, when you're crossing this minefield, being blown up and having these issues.
Before we started the show, I told Ahren that, like, part of the show today, I wanted to talk about potential solutions, as like maybe bankruptcy is not the only solution. But and I actually work with Ahren in that kind of field. But today has been such an informative kind of episode on bankruptcy that I don't even want to touch that. I want to invite you back, and we do another episode on the alternatives to bankruptcy, because that's something that you and I both work on. And I want to kind of leave this episode as a standalone, because the material that you just put out on this episode, I think, is invaluable. And somebody that wants to learn bankruptcy can get the fundamentals, I think, on this particular episode, just enough to educate themselves a little bit before they come and see you and get their, like the full-on consultation or whatever. And of course, by the way, like, nothing that we've said today, and I know you've got, you get the warning at the beginning of the show, this is not legal advice. This is just generalized information, guys. And for specific information, every case is different. So if you think that, you may have a case or you may qualify, you can't just rely on what we're talking about. You've got to go see a lawyer and let them look at your particular materials, your stubs, who you owe and what you owe to them, and your circumstances, for them to make an informed evaluation.
Yeah, please do not watch a 55-minute Bankruptcy 101 video and think you can file bankruptcy. And I just want to reiterate this again and again. Once you file, you cannot unring that bell. Once you file a Chapter 7, there's a couple options. We could try to convert you to a Chapter 13, but you're still stuck. And the trustee, if there are assets that we couldn't protect, or transfers to mom that we now can't stop her from being sued, the only way to avoid that is before you file, not afterwards. It's just mitigating the damages. It's just cleaning up the mess. Your options get very limited. So it's very important. Do not try this at home. Do not do this on your own.
Well, with that said, I think those were wise words, Ahren. I really want to thank you for giving up your time and being on the show. Like, you're awesome, and we're going to have you back for sure to talk about what we just discussed and so much more. You're a great lawyer. I've had amazing experiences with you, and I know we're going to be working together for a very, very long time. So Thanks to you, and thanks to viewers and the listeners. Until next time, guys, keep it legal.
Thanks for having me on. Appreciate it, Abbas.